I have presided over thousands of cases throughout my career. I have watched hardened criminals crumble under pressure. I have seen innocent people break down in tears when the truth finally emerged. I have seen arrogant litigants walk into a courtroom convinced they were untouchable, but the man I'm about to tell you about, he was different, because from the moment he entered my courtroom, he wasn't trying to win his case. He was trying to win a battle against authority itself, and what happened that day became one of the most unforgettable courtroom confrontations I have ever witnessed. Even now, years later, I can still remember the sound of the courtroom door opening, the silence, the tension, the strange confidence on his face, and the exact moment he looked directly at me and said something no experienced litigant should ever say to a judge. "You can't intimidate me." The courtroom froze, but I'm getting ahead of myself. To understand why those words mattered, you first need to understand the people involved. The plaintiff was a woman named Emily Parker, 34 years old, single mother, elementary school teacher, no criminal record, no history of lawsuits, no history of financial disputes, the kind of person who spent more time helping others than helping herself. She wasn't wealthy, she wasn't powerful, she wasn't connected, she simply wanted justice. Sitting on the opposite side of the courtroom was a man named Richard Lawson, 46 years old, successful contractor of a growing construction company, financially comfortable, well-spoken, confident, very confident. In fact, I would eventually realize that confidence was the center of this entire case. The dispute itself seemed ordinary when I first reviewed the file, at least on the surface. Emily claimed Richard had taken nearly $60,000 from her during a home renovation project. According to her complaint, Richard had accepted payment, promised extensive repairs, and then abandoned the project halfway through construction. The result was devastating. Emily's home had become partially unlivable. Walls had been demolished. Electrical work remained unfinished. Plumbing problems had appeared, and much of her life savings had disappeared. Richard denied everything. According to him, Emily constantly changed project requirements. He claimed she refused to pay additional costs. He insisted the delays were her fault. At first glance, it appeared to be a standard contract dispute, the type of case judges see regularly. But experience teaches you something important. The most dangerous cases often look ordinary at first. The truth hides beneath the paperwork and sometimes beneath the personality sitting in front of you. The morning proceedings began routinely. Emily arrived early. She sat quietly beside her attorney, reviewing documents, organizing notes, trying to stay composed. I could see the stress in her face, the exhaustion, the anxiety, the uncertainty. People who enter court hoping for justice often carry a specific kind of fear. They're afraid the truth won't be enough. Emily looked exactly like that. Richard arrived 20 minutes later. The difference between them was impossible to ignore. While Emily appeared nervous, Richard appeared entertained. He walked into the courtroom with the confidence of someone attending a business meeting rather than a legal proceeding. He smiled at spectators, joked with his attorney, looked around the room as if he owned it. I noticed several jurors watching him carefully. Body language matters. More than most people realize, years on the bench teach you how much information people reveal without speaking. Richard revealed plenty. When Emily looked toward the floor, Richard looked toward the audience. When Emily reviewed evidence, Richard checked his reflection in the courtroom windows. When Emily appeared worried, Richard appeared amused. And that contrast immediately caught my attention, not because confidence indicates guilt. It doesn't. But because excessive confidence often creates blind spots. People who believe they control every situation eventually stop paying attention to risks. The trial began. Opening statements were presented. Emily's attorney laid out a straightforward timeline, payments made. Promises given, work abandoned, damages suffered, nothing flashy, nothing dramatic, just facts. Then Richard's attorney stood. His approach was completely different. He didn't focus on documents. He didn't focus on contracts. Instead, he focused on Richard himself. He described him as successful, respected, experienced, trustworthy, almost as if reputation alone should decide the case. I remember listening carefully because whenever an attorney spends more time defending character than evidence, I become interested. Very interested. As the first witnesses testified, a pattern slowly emerged. Former subcontractors described incomplete work. Former employees described unusual management decisions. Several witnesses contradicted portions of Richard's timeline. None of it was devastating individually, but together, the inconsistencies began accumulating, small cracks, tiny fractures, barely visible, yet impossible to ignore once you notice them. Richard seemed completely unconcerned, every contradiction. Every inconsistency, every uncomfortable question, nothing seemed to affect him. He smiled through all of it. occasionally even laughed. At one point, while a witness described unfinished electrical work, Richard leaned back in his chair and shook his head dramatically. Several jurors noticed, so did I. And trust me, jurors noticed much more than litigants realized. By the second day, tension inside the courtroom had increased significantly. Emily appeared emotionally exhausted. Richard appeared increasingly irritated, not worried, irritated, as if he couldn't understand why the proceedings were taking so long. Then came the moment I will never forget, the moment that transformed an ordinary civil dispute into something far more revealing. Richard took the witness stand. For nearly an hour, he answered questions confidently, maybe too confidently. Every answer sounded rehearsed. Every explanation sounded polished. Every mistake had a convenient excuse. I've listened to testimony for decades, and occasionally you encounter someone who isn't testifying. They're performing. Richard was performing. Then Emily's attorney introduced a financial document, a simple document. 1 page, nothing dramatic, but the second Richard saw it, his expression changed. Only briefly, most people in the courtroom missed it. I didn't. Years of judging train your eyes differently. Fear appeared for less than a second, then vanished. The attorney asked where certain project funds had gone. Richard gave an answer. The attorney showed another document. The answer changed. A third document appeared. Another explanation. The jury began taking notes faster. The attorney moved closer. Question after question, detail after detail. The pressure increased, and suddenly Richard stopped looking at the attorney. He started looking at me, directly at me. His jaw tightened, his voice hardened. Then, in front of everyone present, he leaned forward and said something that instantly changed the atmosphere inside the courtroom, something no one expected, something that caused audible gasps from spectators. He looked straight into my eyes and said, "You can't intimidate me." And in that moment, I noticed something far more important than his words, because hidden inside the evidence folder sitting on the attorney's table was a document nobody had discussed yet. A document that would expose a secret Richard had spent years hiding, a secret so damaging that before this trial ended, even his own attorney would struggle to defend him. And Richard had absolutely no idea it was coming. When Richard Lawson looked directly at me and declared, "You can't intimidate me," the courtroom became so quiet that I could hear pages turning in the gallery behind him. Now, let me tell you something I learned after decades on the bench. People rarely say what they appear to be saying. The words themselves are often less important than the reason they are spoken. I hadn't threatened Richard. I hadn't raised my voice. I hadn't even interrupted his testimony. Yet somehow he felt compelled to defend himself against pressure that wasn't coming from me. That observation stayed with me because, in my experience, people reveal their greatest fears when they believe they're revealing their greatest strengths. I simply looked at him, calmly, silently. Then I instructed the attorney to continue. The reaction was immediate. Richard had expected a confrontation. Instead, he received nothing, no argument, no warning, no emotional response. And strangely enough, that seemed to frustrate him more. Believe me, viewers, courtrooms are often psychological battlefields. Many people walk inside expecting conflict. They prepare for resistance. They prepare for criticism. They prepare for confrontation. But silence can be far more uncomfortable, especially for someone who desperately wants control. The attorney resumed questioning. At first, Richard regained his composure. He straightened his tie, adjusted his posture, forced a smile. But something had changed. I could see it. The jury could see it. Even spectators could feel it. The confidence that had carried him through the first 2 days was beginning to crack, not dramatically, not yet, just enough to make people wonder what was happening beneath the surface. Then the attorney introduced the document I had noticed earlier, a subcontractor payment ledger. On its own, it seemed insignificant, the kind of financial record that rarely captures anyone's attention. But experienced trial lawyers don't introduce evidence randomly. Every piece serves a purpose. Every question builds towards something larger. The attorney projected the ledger onto the courtroom screen, rugs of dates, invoices, payment records, transfer numbers. At first glance, it looked painfully ordinary. Richard even smiled when it appeared. That smile lasted less than 10 seconds. The attorney pointed to a payment entry. "Do you recognize this transaction?" "Yes." "And you approved it?" "Yes." "No doubt?" "None." The attorney nodded, then pointed to another entry. "You recognize this one?" "Yes." "And you approved it as well?" "Yes." Richard seemed almost annoyed by the questions, as though they were beneath him, as though the attorney was wasting everyone's time. I've seen that attitude before. It's dangerous, because arrogance often convinces people they understand a strategy long before they actually do. Then the attorney zoomed in on a section near the bottom. The courtroom screen changed. Several numbers became larger. More visible, the attorney turned toward Richard. Can you explain why the account number changed? The smile disappeared, not completely, just enough. Richard glanced toward the screen, then back toward the attorney. Administrative error. A reasonable answer, at least initially. The attorney nodded again, then displayed another document. Same account, different date, different transaction, same unusual account number. Again, Richard blamed administrative error. Then another document appeared, and another, and another. Each one connected to the same account. The same destination, the same unexplained irregularity. Now jurors were leaning forward, actually leaning forward. That's always significant. Jurors pay attention when patterns emerge. Human beings naturally search for patterns, and a pattern was beginning to form. The attorney walked slowly toward the witness stand. No rush, no theatrics, just patience. Then he asked a question that changed the direction of the trial. Mr. Lawson, who owns this account? Richard answered immediately. I don't know. Too quickly. Far too quickly. I noticed it. The jury noticed it. The attorney noticed it. Experienced witnesses usually think before answering important questions. Richard didn't. The answer sounded prepared, automatic, like something he had rehearsed long ago. The attorney paused, then displayed a banking document obtained through subpoena. I remember the exact moment it appeared on the screen because the entire room seemed to shift. Richard's attorney sat upright. Emily's attorney stopped moving. Several spectators whispered, and Richard, for the first time during the entire trial, looked genuinely nervous. The account belonged to a company nobody had mentioned before, a company called Silver Ridge Consulting. The attorney asked a simple question. Have you ever worked with Silver Ridge Consulting? No? Never? Not once? No. The attorney nodded, then clicked a button. Another document appeared, corporate registration paperwork, Richard's signature. His address, his contact information, his name, directly connected to Silver Ridge Consulting, and suddenly the courtroom wasn't quiet anymore. You could feel the energy, the tension, the uncertainty. Richard stared at the screen. His attorney stared at the screen. Even Emily looked confused because this wasn't what anyone expected, at least not publicly. I remember watching the jury. One juror actually lowered his pen and folded his arms. Another exchanged a glance with the juror beside her. That's not something jurors do when evidence is routine. That's something they do when a story starts changing. Richard attempted to recover. He claimed he had forgotten, claimed the company was inactive, claimed it had never conducted business. But every answer created new questions, and every new question seemed worse than the last. Then something happened that fascinated me. The attorney stopped attacking, stopped pressing, stopped pushing. Instead, he sat down, just sat down. His cross-examination ended unexpectedly. That confused everyone, including Richard, especially Richard, because he looked relieved, far too relieved. The witness stepped down. The court recessed for lunch. People flooded into the hallway discussing what they had seen. Reporters began making phone calls. Spectators whispered theories. Even courthouse staff seemed unusually interested. And yet, as I reviewed my notes alone in chambers, one thought kept returning to me. The attorney had ended too soon, much too soon. He had uncovered a hidden company, connected it directly to Richard, created obvious credibility problems, and then simply stopped. That made no sense, unless Silver Ridge Consulting wasn't the destination, unless it was merely a doorway leading somewhere else. When court resumed that afternoon, I received my answer because Emily's attorney called a witness nobody expected, a witness whose name had not been mentioned once during the first 2 days. Witness who looked terrified the moment she entered the courtroom. And the second Richard saw her, the color drained from his face, not slightly, not briefly, completely. At that moment, I knew this case was no longer about a failed renovation project. It was about something much bigger, something Richard had been desperately trying to keep hidden. And as the witness raised her right hand to take the oath, I realized that the trial was about to enter a territory neither side could escape from. What she was about to reveal would force everyone in that courtroom, including me, to question whether the lawsuit we had been hearing was ever the real case at all. The moment the woman stepped into my courtroom, I noticed two things. First, she looked terrified. Not nervous, not uncomfortable, terrified, the kind of fear that settles deep into a person's eyes and refuses to leave. Second, Richard Lawson looked even more frightened than she did, and that immediately caught my attention, because throughout the trial, Richard had projected confidence, sometimes arrogance, sometimes outright defiance. But fear? This was the first genuine fear I had seen from him. The woman introduced herself as Sarah Mitchell, 39 years old, former bookkeeper, former employee of Silver Ridge Consulting, the same company Richard had claimed to barely remember, the same company connected to the mysterious account that had suddenly become the center of the trial. As Sarah took her seat in the witness box, I watched her hands. They trembled visibly. She kept glancing toward Richard, not in anger, not in resentment, in fear. Years on the bench teach you to recognize that distinction. Fear looks different. It carries weight. It changes posture, breathing, eye movement, everything. Emily's attorney approached carefully. No aggressive tone, no dramatic introduction, just one simple question. Ms. Mitchell, how long did you work for Silver Ridge Consulting? Almost 4 years. The courtroom immediately became silent. Because Richard had just testified that the company was essentially inactive, 4 years of employment didn't sound inactive, not even remotely. The attorney continued. What was your position? I handled financial records. A few jurors began writing rapidly. I noticed Richard shift in his chair. His attorney leaned closer and whispered something to him. Whatever it was, it didn't help. Sarah continued. For the next 20 minutes, she described a company that sounded nothing like the harmless shell business Richard had portrayed. Silver Ridge wasn't dormant, it wasn't forgotten, and it certainly wasn't inactive. According to Sarah, it processed substantial amounts of money every month. Money originating from multiple construction projects, money moving through various accounts, money that often became difficult to trace. At first, the testimony sounded technical, financial terminology, accounting procedures, documentation records. The kind of details that sometimes lose a jury's attention. But then something happened. The attorney asked a question that changed everything. Ms. Mitchell, why did you leave the company? Sarah froze. Completely froze. For several seconds, she didn't answer. The silence spread through the room. I remember looking toward the jury. Nobody was distracted. Nobody was looking elsewhere. Every single person was focused on the witness, waiting. Finally, she spoke, because I became scared. The answer landed harder than any legal argument presented so far, because fear creates curiosity. People want to know what caused it, the attorney asked gently. Scared of what? Sarah looked toward Richard, then toward the floor, then back toward the attorney. I discovered things I wasn't supposed to discover. A ripple moved through the gallery. Even now, I remember that moment clearly, not because of what she said, because of what happened immediately afterward. Richard's attorney stood fast, much faster than he had during previous objections. Objection. His voice sounded sharper than usual. More urgent, I considered the objection, allowed limited questioning, and instructed the witness to answer only what she personally knew. Sarah nodded. Then came the testimony that truly shifted the trial. She described invoices connected to construction projects, invoices that appeared legitimate, payments that appeared routine, but according to her, many of the numbers didn't match reality. The subcontractors were listed for work they never completed, material costs were inflated, certain expenses existed only on paper. The attorney displayed records one after another. Sarah identified them, explained them, connected them. The pattern became difficult to ignore. What initially appeared to be a dispute over a home and renovation project was slowly transforming into something much larger, much darker. I watched the jury carefully. And what I saw concerned me, not because they were confused, because they were beginning to understand. Sometimes understanding is more dangerous than uncertainty, because once people see a pattern, they start connecting pieces on their own. And the pieces were beginning to form an ugly picture. Then Sarah said something that changed the atmosphere entirely, something I will never forget. She pointed toward a document displayed on the courtroom screen, a routine-looking transfer record, nothing unusual at first glance. Then she spoke. That account wasn't used to hide money. The attorney paused. What do you mean? Sarah swallowed, then answered. It was used to choose where the money would disappear next. The courtroom became absolutely still. I could practically hear people breathing. Richard stared at her. His expression had changed completely now. The confidence was gone. The amusement was gone. Even the arrogance was disappearing. What remained was calculation. The look of a man desperately trying to determine how much damage had already been done. The attorney approached the witness stand. Who made those decisions? Sarah didn't answer immediately. She looked directly at Richard for several long seconds. Then she said 2 words. Richard did. The impact was immediate. Richard's attorney objected again. Spectators whispered, jurors exchanged glances. And through it all, Richard remained motionless, almost unnaturally motionless. That bothered me very much, because sometimes people react emotionally when they're cornered, others react strategically. Richard belonged to the second group. His mind was working, constantly meeching, calculating, planning. I could see it. The attorney continued questioning. The testimony became increasingly damaging. Transfer records, Tinnell communications, financial instructions. Sarah seemed to possess knowledge of nearly every important transaction, far more knowledge than anyone expected. Far more knowledge than Richard appeared prepared for. Then came the moment that changed my own view of the case. The attorney displayed an email. Short, only a few lines long. Sarah identified it immediately. The sender was Richard Lawson. The recipient was Sarah. The date was 3 years before the lawsuit. The attorney asked her to read a specific sentence aloud. Her voice trembled as she read. If questions ever arise, we already know who takes the blame. The courtroom exploded with whispers. I struck the gavel. Order returned, but inside my mind, something had changed, because those words didn't sound like ordinary business communication. They sounded like preparation for something. The attorney asked the obvious question: who was supposed to take the blame? Sarah looked toward Emily, then toward the jury, then finally back toward the attorney. Her answer stunned everyone. Whoever was convenient. The silence afterward felt endless. I have witnessed emotional testimony, angry testimony, heartbreaking testimony, but there is something uniquely unsettling about calculated testimony. Testimony describing plans made years in advance, plans designed around future victims, future scapegoats, future excuses. And suddenly a troubling possibility entered my mind. What if Emily Parker wasn't the first target? What if she wasn't even the intended target? What if this entire lawsuit was merely the latest chapter in a much larger scheme? As the afternoon continued, that possibility became increasingly difficult to ignore, because Sarah wasn't finished, not even close. Near the end of her testimony, she revealed the existence of something nobody had previously mentioned, something she had secretly kept for years, something she claimed contained records Richard believed had been destroyed. The attorney asked what it was. Sarah reached into her bag. The courtroom watched. Richard watched. I watched. Then she placed a small external hard drive onto the evidence table. And the moment Richard saw it, every trace of confidence vanished from his face. I will never forget that expression, because it wasn't anger, it wasn't frustration, it wasn't even panic, it was recognition. The look of a man staring directly at the one thing he hoped would never resurface, and at that moment I realized the trial was about to become far more explosive than anyone imagined, because according to Sarah, that drive contained evidence reaching back nearly 7 years, evidence involving multiple projects, multiple victims, and possibly multiple crimes. But what investigators would discover inside that device the following morning would shock the courtroom, stun the jury, and reveal a truth so disturbing that even I struggled to believe it when I first saw it. I've often said that evidence tells stories, not immediately, not all at once, but piece by piece. A document reveals one detail, an email reveals another, a witness fills in the gaps, and eventually the truth begins to assemble itself. The morning after Sarah Mitchell produced the external hard drive, my courtroom felt different, heavier, more focused. The casual curiosity that had filled the gallery during the first days of trial had disappeared. People weren't attending because of a construction dispute anymore. They were attending because they sensed something much larger was unfolding. Reporters arrived earlier than usual. Every seat was occupied before proceedings began. Even courthouse staff, who normally paid little attention to civil trials, seemed unusually interested. And at the center of it all sat Richard Lawson, the man who had once walked into court with a smile. That smile was gone. He still wore an expensive suit, still carried himself carefully, still attempted to project confidence. But confidence is difficult to maintain when uncertainty enters the room. And uncertainty had become his constant companion. I noticed something else that morning. For the first time during the trial, Richard avoided eye contact, not with me, with everyone. Jurors, witnesses, spectators, even his own attorney. That observation stayed with me, because people who feel powerful usually seek connection. People who feel vulnerable often avoid it. Court resumed. The attorney informed the court that forensic specialists had examined portions of the hard drive overnight. What they discovered raised serious questions. Questions that extended far beyond Emily Parker's renovation project. The attorney approached the evidence screen. The room became silent. Then he displayed the first recovered file, an internal spreadsheet, thousands of entries, dozens of projects. Hundreds of transactions. At first glance, it appeared to be ordinary accounting data, but appearances can be deceptive. The attorney highlighted certain columns. The jury leaned forward. I remember watching their faces. Confusion slowly transformed into understanding, and understanding slowly transformed into concern, because next to numerous project names appeared a category label, a category that should not have existed. The label simply read, Recovery Candidate. The attorney paused, then asked Sarah Mitchell what the term meant. Her answer chilled the room. According to Sarah, recovery candidate referred to customers selected for financial manipulation, clients who were unlikely to fight back, clients with limited resources, clients who lacked legal experience. The clients who could be blamed if financial questions ever arose. The silence that followed was unlike anything I had experienced during the trial. No whispers, no movement, nothing, just silence. The kind of silence that appears when people realize they are looking at something deeply calculated, something intentional. The attorney displayed another file. This one contained internal notes, comments, assessments, evaluations. And suddenly the case became even more disturbing because the files didn't simply track projects. They tracked people, their financial situations, their personal circumstances, their vulnerabilities. I watched the jury carefully. Several jurors stopped writing entirely. They simply stared. Sometimes evidence becomes so shocking that note-taking feels unnecessary. This was one of those moments. Then Emily Parker's name appeared on the screen. The courtroom collectively inhaled. Next to her file was a detailed profile: widowed, limited savings, single income, household, low likelihood of prolonged litigation. The attorney read the notes aloud. Each sentence made the atmosphere darker, not because of what happened, because of how deliberately it appeared to have been planned. And then the attorney revealed something that completely changed the direction of the trial. A separate category existed within the files, one even more troubling than recovery candidate. The category was labeled Shield. Nobody understood what it meant, not yet. The attorney asked Sarah. She looked visibly uncomfortable, more uncomfortable than she had been at any point during her testimony. I noticed her breathing change, her hands tighten, her eyes lower. Those reactions mattered because they suggested she already knew how serious the answer would be. Finally, she spoke. A shield was someone selected to absorb responsibility. The room became motionless, she continued. If investigators, customers, auditors, or attorneys started asking questions, she hesitated. The shield became the explanation. The attorney nodded. An explanation for what? Everything. The word echoed through the courtroom. Everything. I felt a strange sensation at that moment. Not surprised, not exactly. Something closer to realization. Pieces that had seemed disconnected were beginning to align. The hidden company, the financial transfers, the mysterious emails, the careful profiling, the unusual lawsuit. Suddenly they all pointed toward the same possibility. A possibility that became even more troubling when the attorney displayed another recovered file. A list, just a list. Names, dates, projects, nothing dramatic, at least initially. Then the attorney zoomed in, and there it was. Emily Parker's name. Beside it appeared a status note, potential shield. Several people gasped. Richard's attorney immediately objected, but the damage was done. The jury had seen it. Everyone had. Emily herself looked stunned. I watched her expression carefully. This wasn't the reaction of someone learning she had been overcharged. This was the reaction of someone realizing she may have been selected for something far worse. The attorney continued. What does potential shield mean? Sarah swallowed hard, then answered. It means someone is being prepared. Prepared for what? To take the fall. The room erupted with whispers. I struck the gavel repeatedly. Order returned eventually. But internally, I knew the trial had crossed an invisible line, because if Sarah was telling the truth, then Emily hadn't simply become involved in a financial dispute. She had become part of a contingency plan, a human contingency plan. The attorney spent the remainder of the day examining additional files. Each revelation seemed worse than the one before. Parts emerged. Projects repeated. Names reappeared. Financial paths connected. And throughout it all, Richard remained strangely quiet. Too quiet. That bothered me, because people react differently when cornered. Some become emotional. Some become defensive. Some become angry. Richard became observant, almost detached, as though he were studying the situation rather than experiencing it. Years on the bench have taught me to pay attention to moments like that, because silence can mean many things: acceptance, defeat, calculation. And I couldn't yet determine which one applied to Richard. Then, late in the afternoon, something happened that nobody expected. A forensic analyst took the stand. He had been reviewing deleted files recovered from the hard drive, thousands of files. Most were damaged, many were incomplete, but a handful remained intact. The attorney asked if anything significant had been recovered. The analyst nodded, then displayed a directory of recovered recordings, audio recordings, dozens of them private meetings, Bontain calls, tenor discussions. The courtroom instantly became alert. The analyst explained that several files appeared relevant to the case. One recording in particular stood out. The date attached to it was 4 years old. The participants had not yet been identified, but portions had already been transcribed. The attorney asked whether the recording had been reviewed. The analyst answered yes. Then he said something I will never forget. There is a statement in the recording that changes the interpretation of this entire case. The courtroom became absolutely silent. The attorney asked him to elaborate. The analyst glanced toward the judge's bench, then toward the jury, then toward the evidence screen. Finally, he answered. The speaker discusses selecting individuals to carry legal responsibility if financial operations are ever exposed. Every person in that room understood the implication immediately, every single one, but then came the truly shocking part: the analyst wasn't finished. Because according to the recovered transcript, one specific name was mentioned repeatedly, a name nobody expected, a name that connected directly to someone already sitting inside my courtroom. When the attorney asked whose name appeared in the recording, the analyst slowly turned toward the defense table, and Richard Lawson's face lost every remaining trace of color, because the name wasn't Emily Parker, it wasn't Sarah Mitchell, and it wasn't Richard Lawson. It was the name of someone nobody had ever suspected, someone whose testimony had already been presented under oath, and if the recording was authentic, that person had been lying from the very beginning. I have presided over cases where a single photograph changed everything. Cases where one witness destroyed months of carefully constructed testimony, cases where a forgotten document exposed years of deception. But what happened next remains one of the most shocking moments I have ever witnessed inside a courtroom. Because sometimes the truth doesn't arrive quietly, sometimes it detonates. And when it does, everyone in the room feels the impact. The forensic analyst remained seated in the witness box. The courtroom was so silent that nobody seemed willing to move. Not the jury, not the attorneys, not even the spectators packed into the gallery. Everyone was waiting for the same answer. The analyst had just revealed that a name repeatedly appeared in the recovered recording, a name belonging to someone who had already testified, someone who had potentially lied under oath. I remember looking around the room. People weren't blinking. They weren't shifting in their seats. They were frozen. The attorney took a breath, then asked the question, "Whose name appears in the recording?" The analyst answered, "Melissa Carter." For a moment, nobody reacted, not because they didn't understand, because they did. They were processing it. Melissa Carter, the former accountant, the first witness, the woman whose testimony initially helped support Richard's version of events, the woman who had appeared calm, professional, credible, the woman who had helped establish the foundation of the entire lawsuit, and suddenly that foundation was shaking violently. The courtroom erupted. Whispers exploded through the gallery. Jurors exchanged stunned glances. Emily Parker covered her mouth. Even Richard's attorney looked blindsided. I struck the gavel repeatedly. Order returned eventually, but the atmosphere had changed forever. The attorney requested permission to call Melissa Carter back to the stand. I granted it, and about 20 minutes later, Melissa re-entered the courtroom. I will never forget her expression because she looked completely different from the woman who had testified earlier. The confidence was gone. The professionalism was gone. Even her posture had changed. Fear was written across her face. The moment she sat down, she avoided looking at anyone, especially the jury. That's always significant. Jurors pay close attention to eye contact. People underestimate how much nonverbal behavior influences credibility. The attorney approached carefully. No aggression, no raised voice, just precision. He began with simple questions, questions about her previous testimony, questions about financial records, questions about Silver Ridge Consulting. Melissa answered cautiously. Every response sounded measured, controlled, carefully selected. Then the attorney displayed the recovered transcript. A large screen illuminated behind him. The courtroom watched. Melissa stared at the evidence, and I watched something happen in real time. The moment she recognized the document, her face changed completely. The attorney pointed to a specific section. "Do you recognize this conversation?" "No." "You're certain?" "Yes." The attorney nodded, then he played the audio. The effect was immediate. A voice filled the courtroom speakers. Clear, undeniable, Melissa's voice. The room froze. I have seen witnesses caught in contradictions before, but there is something uniquely devastating about hearing someone's own voice dismantle their testimony. The recording continued. Melissa discussed project files, financial transfers, Tinnell reports. Then came the statement that altered the entire trial. The recording captured her asking a question, a simple question, one sentence. "Who are we setting up this time?" The courtroom became motionless. Nobody moved, nobody spoke, nobody even seemed to breathe. The recording continued. Then another voice answered. Richard Lawson's voice, calm, casual, almost conversational, as though discussing an ordinary business decision. The attorney played the next portion. And what the jury heard next would become the defining moment of the entire case. Richard's recorded voice said, "Whoever is easiest to blame." Silence, Dapsio's silence. I looked toward the jury. Several members looked genuinely shocked. One juror slowly removed his glasses. Another simply stared at the screen without moving. Emily Parker had tears in her eyes. And Richard? Richard finally looked defeated. Not nervous, not frustrated, defeated, because some evidence cannot be explained away. Some evidence doesn't leave room for interpretation. This was one of those moments. The attorney continued playing segments. Each recording painted a clearer picture, a darker picture, a picture of a system designed to protect certain individuals while sacrificing others, potential shields, recovery candidates, financial diversions, manufactured explanations. Everything Sarah Mitchell described was now being supported by Richard's own recorded conversations. Then came the viral courtroom moment, the moment nobody expected, the moment that would later spread across news outlets and legal commentary channels for months. The attorney played one final recording, a meeting held approximately 18 months before Emily hired Richard. In the recording, multiple voices discussed future risks, potential audits, possible investigations, contingency plans. Then Melissa asked a question. What happens if someone takes us to court? Richard laughed, actually laughed, then answered, "They'll never beat us. People believe money." The room went silent. His voice continued, "People trust success." Another pause, then the sentence that changed everything. "They don't care about the truth." I remember looking around the courtroom. The impact was extraordinary because the jury wasn't just hearing evidence. They were hearing arrogance, belief philosophy, the underlying mindset behind everything that had happened. Years on the bench have taught me that evidence matters, but character often reveals itself in moments people never expect others to hear. This was one of those moments. The attorney stopped the recording, then turned toward Melissa. "Was that Richard Lawson?" Melissa stared at the table. "Yes." "Did those conversations occur?" "Yes." "Did you previously tell this court they did not?" Silence, the longest silence of the trial. Then Melissa began crying, not dramatically, not theatrically, quickly. The kind of crying that comes when someone realizes the truth has finally outrun the lie. And then she said the words nobody expected, words that detonated inside the courtroom. "I lied." The gallery erupted. I immediately restored order, but internally, I knew the case was over, not legally, not officially, but practically the central narrative had collapsed, the deception had been exposed, the recordings had connected the pieces, the witnesses had confirmed them. And now one of the key participants was admitting dishonesty under oath, yet even then, the biggest revelation was still waiting, because during redirect examination, Melissa revealed one final truth, a truth so shocking that even I struggled to process it. According to Melissa, Emily Parker had never been the original target. She had never been the intended shield. She had never been the first choice. The entire plan had originally been built around someone else, someone much closer to Richard. Someone whose betrayal had triggered the chain of events that ultimately exposed everything. And when the jury learned who that person was, the emotional impact would be unlike anything I had ever witnessed inside a courtroom. After more than 20 years on the bench, I believed I had developed a certain immunity to shock, not because I had become indifferent, quite the opposite. Experience teaches you to expect the unexpected. It teaches you that people are capable of extraordinary kindness and extraordinary cruelty. But what Melissa Carter revealed during the final phase of that trial stayed with me long after the courthouse emptied, because beneath every financial scheme, every forged record, every manipulation, there is usually something deeply human, a choice, a betrayal. Moment when someone decides who matters and who doesn't, and that was exactly what we were about to uncover. The courtroom remained silent as Melissa wiped tears from her eyes. She looked exhausted. Like someone who had been carrying a burden for years and could no longer hold it, the attorney asked carefully, "If Emily Parker wasn't the original target, who was?" Melissa hesitated. Then she turned toward Richard. For several seconds, neither spoke. The entire courtroom watched. Finally, she answered, "His brother." A murmur swept through the gallery. Richard closed his eyes, just briefly. But I saw it. And in that moment, I knew the answer was true. The attorney continued. "Please explain." Melissa took a deep breath. Then she told the story. Years earlier, Richard had built much of his business with help from his younger brother, Michael Lawson. According to the testimony, Michael handled operational responsibilities while Richard controlled finances. For years, the partnership appeared successful until Michael began asking questions about accounts, questions about missing funds, questions about projects that didn't add up. The deeper Michael looked, the more concerned he became. Eventually, he threatened to report irregularities. That's when everything changed. According to Melissa, internal discussions began almost immediately, not about fixing problems, not about correcting mistakes, about protecting Richard. The recordings recovered from the hard drive supported her account. Plans were discussed. Scenarios were considered. Strategies were created. And among those strategies was one particularly disturbing idea. If financial misconduct were ever discovered, Michael would become responsible. He would become the explanation, the shield, the person left carrying the blame. But something happened Richard never anticipated. Michael quietly gathered evidence, years of evidence, sums, financial records. Then, before he could act, he severed ties with the company entirely. The plan collapsed, the intended shield escaped, and according to Melissa, Richard spent years searching for alternatives, new explanations, new scapegoats, new people who could absorb responsibility if problems surfaced. Eventually, that search led to customers like Emily Parker. As I listened, I found myself studying the jury. Many looked angry, others looked saddened, several appeared genuinely disturbed. I understood why, because this case was never truly about money. Money was simply the mechanism. The real issue was something else, the willingness to sacrifice innocent people to preserve power. That realization hit the courtroom hard. The defense attempted damage control. They challenged timelines, questioned motives, attacked witness credibility, but by then, the evidence had become overwhelming. The recordings, the documents, the financial records, the testimony. Everything pointed in the same direction, and when independent forensic experts confirmed the authenticity of the recovered files, the remaining doubts began disappearing rapidly. Then came Richard's final opportunity. His attorney called him back to the stand. I watched carefully because sometimes people surprise you at the end, sometimes they accept responsibility, sometimes they reveal genuine remorse, sometimes they choose honesty. Richard did none of those things. Instead, he attempted one final defense. He argued that everyone misunderstood, that the recordings lacked context, that business decisions had been mischaracterized, that former employees were motivated by resentment, but something had changed. Not in the evidence, in the jury. I could see it. The persuasive confidence that once defined Richard no longer existed, because credibility, once broken, is incredibly difficult to rebuild, particularly when your own words become your greatest enemy. The trial concluded several days later. The jury deliberated, and during those hours, I reviewed my notes, thousands of pages, dozens of witnesses, hundreds of exhibits. I thought about Emily Parker, a woman who simply wanted repairs to her home. I thought about Michael Lawson, brother who became a target because he asked questions. I thought about Sarah Mitchell, a witness who lived with fear for years. And I thought about Richard, a man whose greatest mistake wasn't greed. It was believing he was smarter than consequences. Eventually, the jury returned. I will never forget that moment. The foreperson stood, the courtroom rose, and then came the verdict. The jury found overwhelmingly in favor of Emily Parker. Damages were awarded. Financial penalties, followed by findings of fraud, were established. Additional referrals were made for further investigation beyond the civil case. The legal consequences would continue long after my courtroom's involvement ended. But what stayed with me wasn't the verdict itself. It was Richard's reaction. Because throughout the entire trial, he fought desperately to control the narrative, to control perception, to control reality. And when the verdict was read, that control finally disappeared. For the first time, he looked like an ordinary man facing the consequences of his choices, nothing more, nothing less. The courtroom slowly emptied afterward. Jurors departed. Attorneys gathered files. Spectators discussed what they had witnessed. Emily sat quietly with tears in her eyes. Not tears of triumph, tears of relief. There's a difference, and it's an important one. Relief comes when a burden finally ends, when uncertainty finally lifts, when the truth finally catches up. Years have passed since that trial. I have handled countless cases since then. Most have faded into memory. This one never did, because it reminded me of something every judge eventually learns. The most dangerous people are not always the loudest. They are not always the most aggressive. Sometimes they are the most confident, the ones who believe success makes them untouchable, the ones who believe appearances matter more than truth, the ones who convince themselves that accountability only happens to other people. Richard Lawson believed money would protect him. He believed reputation would protect him. He believed influence would protect him. But in the end, none of those things mattered, because evidence doesn't care about status. Facts don't care about wealth. And the truth has a strange way of surviving. Even when people spend years trying to bury it, I still remember the moment he looked directly at me and said, "You can't intimidate me." The irony is that nobody was trying to intimidate him. The evidence was simply catching up. And evidence doesn't need to raise its voice. It only needs to exist. That, perhaps, is the most important lesson from this case. You can manipulate people, you can manipulate records, you can manipulate appearances, but eventually reality demands payment, and when that day comes, confidence alone is never enough. So let me ask you something. If that hard drive had never been discovered, how many more people would have become shields before someone finally uncovered the truth?